Good morning, everybody, and welcome to the District of Columbia Court of Appeals. We have just one case, though it's a big one, on this morning's calendar, which is a special sitting. It is number 23 CF 205 and 23 CF 229. RONNIKA or RONNIKA, M. Jennings versus United States, and Derek Brian Turner versus United States. Whenever you're ready, counsel. Maybe you can explain to us how you plan to divide your time.
As I understand, Matthew Martins of Wilmer Cutler Pickering Hale and Dorr for defendant and appellant RONNIKA Jennings. And I believe the clerk advised us we would each have 8 minutes.
Okay.
RONNIKA Jennings has been imprisoned for 7.5 years, originally charged with 45 counts, including murder under a Pinkerton theory. But the prosecution of Ms. Jennings has been deeply flawed from the outset. At trial, Ms. Jennings was acquitted of 40 of the 45 counts after a 9-week trial and 9 days of jury deliberations. On appeal, the government now concedes that one of the 5 counts is defective and must be vacated, the obstruction of justice charge. And so we're here today only on the 4 accessory after the fact charges. It's worth noting that at trial, those 4 accessory after the fact charges were very much an afterthought, with less than 1 page of closing argument devoted to the government's argument with regard to those charges. The government didn't spend much time on those charges, but when you actually dig into the evidence on those charges, they fail. I'd like to focus this morning on one of the 4 AAF charges, the AAF to the March 2017 McFadder murder. And I want to focus on that because that's the only charge on which Ms. Jennings is currently incarcerated. AAF to murder, as this court knows, is a serious charge, but it's difficult to prove. Difficult because the government both must prove the underlying crime by the principal, and in addition, satisfy a stringent knowledge element as to the accessory, actual and personal knowledge that the principal had committed the underlying felony, and a requirement of intentional assistance of a particular sort. As this court explained in Outlaw, that assistance has to be helping the defendant, the principal, avoid arrest, helping him break out of jail, or helping him silence a witness.
Counsel, let me ask you a question, and you can help me think about this. I take it that the AAF charges each were tied to a particular incident, a particular murder or assaultive incident.
Correct.
But Mr. Turner also was charged with conspiracy to do various things, including conspiracy to commit these very same offenses. I'm thinking, is that correct? So as to the March 20th incident you're talking about, he was charged with conspiracy to commit that offense. Is that correct?
Mr. Turner was correct.
Mr. Turner was.
And Ms. Jennings was.
Correct.
Ms. Jennings
I'm getting to a
Okay.
question, believe it or not.
I know.
Here's my question. Even if we're persuaded that the evidence was not sufficient to prove that Ms. Jennings knew of Mr. Turner's involvement in the particular incident, was it enough if the evidence was sufficient to show that she knew of his involvement in beefs between the neighborhood gangs, knew of his involvement in conspiracy to sort of commit murders and assaults and property destruction, including the incident to which this particular conviction is tied? Is that enough? Or does she have to know that he was involved in that particular incident?
In that
You
particular.
understand my question?
I do. And I think the answer is crystal clear under this court's case law. There is no AAF to conspiracy. There's no AAF to conspiracy charge. That's not even a crime. She was charged with AAF to particular events. So 3 of the counts were AAF to the February 17th shooting by Turner. And the particular people that Turner was alleged to have shot on those dates. Rasheem Osborne, Joseph Tyler, and Andrew McFadder. Those were the charges. It was not AAF to conspiracy. It was not AAF to a long-running beef. It was not AAF to a rivalry. The indictment charge and the instructions were that it was AAF to those 3 shootings on February 17th and AAF to the McFadden murder in March of 2017. Those were the specific charges. And it's those underlying felonies that the government must prove that Ms. Jennings had actual and personal knowledge that Turner had committed, and that she had that knowledge at the time she acted to assist. So I don't believe that sort of general, I don't believe that, I think the law is crystal clear, and particularly given the indictment, that she had to know Turner had committed the particular charges. And there is literally no evidence of that knowledge. And
Well, I guess you're making 2 points. You're saying the law is crystal clear on this, and
Yeah.
you can tell me which case you think makes it crystal clear. But your other point is the way this was teed up for the jury and the way it was charged is that she was charged with accessory after the fact to the particular incidents, the particular 4 incidents as to which she was convicted,
Yeah.
and not to conspiracy.
Correct.
Those are your
so
2
I think,
points.
yes, Outlaw and Hawkins are the leading cases from this court describing what the elements are. And they say that there has to be a felony committed by the principal. That's the first element.
Right.
And so the question is, what in this case did the government charge was the felony, and what was the jury instructed was the felony? And both the indictment and the jury instructions make clear what the underlying felonies were that the government was arguing here were the underlying felonies. The 3 assault with intent to kill while armed on February 17th and the murder of McFadden on March 1st. Those were charged and instructed as the underlying felonies that Ms. Jennings was purportedly an accessory to.
Mr. Martins, can I dig into the assistance part of your argument
Sure.
for a moment? Putting aside the knowledge piece for a minute. Is it your position that if the principal, based on the information received from the alleged accessory, chooses not to flee, chooses not to hide out, based on the nature of the information given to them, that precludes an accessory conviction?
I don't think that's what this court said in Butler. So in Butler, this court said most of the ones are cases in which someone acts, but at a minimum, it has to be information on which the person could act in one of the ways covered by accessory after the fact. So Butler says the information has to be such that the person could flee, could escape from jail, or could silence a witness. And that's discussed specifically in this court's Butler case, not the Maryland Butler case, this court's Butler case in 1984.
Right. So, I mean, so you seem to be saying that if the state of affairs at the time that the accessory provides the information or accesses the information happens to be fortuitously, I guess, for the principal, that law enforcement is not onto them yet, or something like that, that happenstance precludes an accessory liability?
No, so I'm saying 2 things. One, just to take the March 1st murder, Ms. Jennings never accesses a police database after McFadden's death on March 5th. In fact, she never accessed a police database after March 2nd, so she had nothing to assist with. The government says, well, she could have told him, if she had accessed a database, presumably, that he wasn't a suspect or that he wasn't. But that's the exact opposite of what they have to prove. What they have to prove is that she provided assistance to help him flee. I grant that maybe he doesn't have to flee to complete an AAF, but she has to help him flee. Telling someone they're not a suspect doesn't help them flee. It tells them they don't have to flee. That's the exact opposite.
Right. So you do seem to be agreeing with my hypothetical or my premise, which is that if someone happens to not be a suspect, and therefore the information is you don't have to flee, then we don't have accessory liability.
That is not accessory after the fact. It may be other things. It is not accessory after the fact because, as this court said in Outlaw, looking back to the common law, it has to be something that could assist someone in fleeing, breaking out of jail, or silencing a witness. That's the opposite of telling someone you don't have to flee. And so assisting someone in fleeing is a requirement here. And the government argued the exact opposite, that my client comforted him such that he knew he didn't have to flee. That's not helping him flee. The government's theory doesn't make any sense because, again, my client never looked at a police database after 7:21 a.m. on March 2nd, 3 days before Mr. McFadder died. My client never, I mean, this is clear in the record and is a critical point. The government's entire theory, page 4 of their brief, and they say this crystal clear. Jennings continued to monitor the police investigations and share information with Turner until his arrest for murder in September 2017. Respectfully, that's fiction on this record. She never looked at a police database after March 2nd at 7:21 a.m.
Can I ask you to clarify something, just to make sure, something you talked about, to make sure I understand? You gave the 3 examples of helping to flee, helping to break out. What is the other one?
Silencing a witness.
And you're treating these as exclusive? And what is the authority that these are exclusive as opposed to examples?
This court's decision in Outlaw.
And can you say, do you have that? I mean, do we actually say, and no other things that, no other conduct
So in Outlaw,
falls within the scope of it, something like that?
I'm sorry, I didn't mean to
Yeah,
interrupt the court.
no problem.
So the court in Outlaw asked the question on page 411. The court says, quote, what kind of conduct aids a principal to avoid detection or apprehension? The court then notes that in 1765, Blackstone wrote any assistance, whatever. But then the court says, Blackstone provided the following illustrations. The court walks through the illustrations by Blackstone. The court then walks through the successor commentator illustrations by Lefebvre. And the court then says on page 413, we decline to construe the AAF statute expansively as to reaching conduct which falls so far short of the illustrations of accessoryship provided by Blackstone more than 2 centuries ago in Lefebvre and Scott in more recent times. So the court stated there that they declined to extend it beyond those examples.
Well, no, I don't think that's not my reading of what we said. What we seemed to say was on the facts of that case, the facts fall well short of the illustrative examples given in Outlaw, and the court wasn't going to extend it in that case. But I don't think we were saying that those 3 illustrative examples are the only instances that can qualify for accessory evidence.
The court certainly did say it didn't satisfy those examples, but the court said we declined to construe the AAF statute expansively.
So expansively as to cover the conduct at issue in this case, I think is what.
That's not what, respectfully, Your Honor, that's not what the court said. They said reaching conduct which falls short of the illustrations of accessoryship. That's what the court said. And so
Did we say falls short or falls far short?
which falls so far short of the illustrations of accessoryship.
So far short, yeah, that one introduces some ambiguity at least, right?
Also, I'm sorry. I wonder whether it leaves open the possibility of something that doesn't fall short, but is different, but, on the same scale, something different, like perhaps what happened here.
So I guess I suppose that's possible, that the so far short leaves some ambiguity, as the judges are stating. But again, the critical point here is she did nothing. After March 2nd, she had no information. The government's theory in its brief on page 4 is that she was providing confidential police information. They say that over and over. That is a factual impossibility on this record, because she never looked at a police report after March 2nd.
As to the murder, right?
She never looked at a police report as to the murder. She never looked at a police report again as to the February 17th AWICS as well. At least as to the murder, she never looks at a report again after the death. There's nothing to share. The government's entire theory that she's sharing information is not true. There's no information to share. It's also important to recognize that she does not look at Wales and NCIC. The government mentions that with regard to the prior crimes back in November and January, that Ms. Jennings accessed Wales and NCIC. And the reason that's important is because the testimony at trial was the only place you could find warrant information was Wales and NCIC. And Ms. Jennings never, as to the February 17th shootings or as to the March murder, ever looks at Wales or NCIC with regard to those events. So even this idea like that she could look at something and help him flee, she's not looking at whether or not he is subject to a warrant that she could even tell him about. She doesn't have that information. And what's in the report matters as well, because what's in the reports is nothing. If you look at the March 1st murder, there's no suspect identified. Mr. Turner's not identified as a suspect. It says blackmail. That's all it says. There's no witnesses identified. So and the last report Ms. Jennings sees on March 2nd says McFadder's alive.
Do you recall what she was talking about during her interview when she kept referring to looking at something because someone had come to Mr. Turner's mother's home and she looked, I thought she said she looked to see whether there was a warrant. What, do you recall what I'm talking about?
I do recall.
Was
and
that her looking into Wales but was that at a different time?
So a couple of things. One, Detective Fultz responds to that and says, that's something in the middle. I'm talking about at the end. So he places whatever that thing was with them going to the mother's house as at an earlier time. He describes that as in the middle. And that is in fact what the documentary record shows, that to the extent she was looking at Wales and NCIC, it was long before February 17th. It was not in connection with either the February 17th AWIC or with regard to Wales. She did, or with regard to the March 1st murder. She did not look at Wales or NCIC with regard to those events. So if you step back to the knowledge element, you say, what is the evidence of actual or personal knowledge? Hockheimer says it cannot be simply suspicion. The Lefebvre says as well, it cannot be suspicion.
So the universe of cases that you're imagining would satisfy the knowledge element is essentially consists of situations where the accessory saw the crime occur or was explicitly told by the principal that they committed the crime. I mean, do you have any other potential examples of?
Those are the ones I could think of. I guess you could have a situation where perhaps they saw a video on TV, maybe like there's a police report about it, and they see the video and recognize the person. But the issue in Butler, this issue is expressed explicitly at issue in Butler, where the court, and there's a dissenting opinion by Judge Pryor, and Judge Pryor says that you don't need personal knowledge. All you need is information sufficient to give one reasonable grounds to believe. And the majority says not correct, says it's personal knowledge. Personal knowledge is a term known to this court, known to the courts. It's the exact same standard necessary for someone to testify. This court uses the language personal knowledge as what's necessary to lay the foundation for someone to testify as a witness. And there is no argument here that there's any evidence that Ms. Jennings had personal knowledge. There's no evidence that Turner told her anything about what he did. And there's no evidence in the documents that even if you believe she looked at the Cobalt reports in response to those calls, the Cobalt reports don't describe Turner, don't describe the person, don't have Turner's name. And Turner was never charged with these things until months later.
We're on a sufficiency issue here, claim here. So I think we all agree that juries can draw reasonable inferences from the evidence. I guess your point here is that the jury would be reasonably inferring that Ms. Jennings reasonably inferred that Mr. Turner committed these crimes, which would not be permissible. But at what level, at what point can the jury reasonably infer that Ms. Jennings would not be doing these things if she didn't actually know? Can the jury infer actual knowledge is I guess my question.
So I think the question of can the jury infer, the question would be from what would the jury draw that inference? What is it that would signal that Turner did it? In other words, you don't have Turner acting in a way afterwards that would give some insight into what was said during the conversation.
Well, I guess the inference would probably be from the level and nature and amount of communication between Mr. Turner and Ms. Jennings.
But I think that all that gives you,
and the intensity of it, I guess.
I think all that gives you is that he's at most that gives you that he's interested in the events. But why? It's an ongoing gang rivalry. Is he interested because he did it? Is he interested because somebody shot one of his people?
Right, but what I'm trying to explore is at some level, that's requiring the government to disprove innocent theories, right? And we've said that that's not a piece of the sufficiency analysis. So at some level, if someone is repeatedly contacting someone urgently, and I'm not saying these are necessarily the facts of this case, and you'd probably dispute that, but saying, help me out, what happened? I gotta know, but never says, I did it, right? At what point can a jury reasonably infer that none of this would be happening if the alleged accessory didn't know that the principal committed the offense?
I can't tell you, what I can say is that I don't actually think that the timing here is so tight. If you look at, for example, the February 17th incident, the shooting's on the 17th of Friday, there's a call on the 20th, she looks at the report on the 21st, there's a call on the 22nd. It's not as if she's getting off the phone and jumping on the reports. There doesn't seem to be any urgency. But the bigger point is this: at the end of the day, it's the government's burden to prove she knew. And here's what's, I think, a critical fact here. She does not look at Wales or NCIC for a warrant for Turner. If this conversation is all about Turner doing it in some way and worried about being apprehended, she doesn't look at the one place that she had looked previously. She does not look at the one place where you'd go to answer that question. She does not look at Wales or NCIC. And so she does not, so that indicates, if anything, whatever's being discussed here, he's not signaled it's about me. And even after he's picked up on the federal charge on the gun possession, she doesn't go back and look at the February 17th or the March 1st reports. So I don't know what the jury would be concluding from other than speculation. This court in Hawkins had an instance in which there were call logs, and the court's words were it would be pure speculation to say what those conversations were about. In the Butler case, one of the person charged with being accessory goes and visits somebody in jail. And this court said we can't infer what the conversation would be about. That's speculation, not inference. And so you have them talking about it. The government is saying the subject matter, because she looks at the reports, must have been the shootings. Even granting that, the specifics of the conversation matter.
What is the conversation? I'm sorry, there's so much in this record. I might be asking a question that makes no sense, but where I think she's provided there, one of the girlfriends might be involved and she's providing some information, and Mr. Turner says, I'm so happy. You know, it seems to be conveying that you're okay on this one. You're okay on whatever one they're talking about. Are you just saying that doesn't mean he did it?
So you're referring to the May 31st incident.
Okay.
Right? This is the jail call where Marche Hazelwood is on the phone with Mr. Turner in the jail, and Hazelwood texts. She conveys what she purportedly had a conversation with Jennings about, and she texts Jennings while she's on the call. So we still have the same problems. He's in jail, not on the murder. He's in jail on the 922G from having a firearm when his car is searched on March 8th when he is shot at. So there's no indication in that conversation that they are discussing the murder. There's no mention of murder. It's talking about, and so whatever said, that the statement about not fishing, and I think she says no evidence about what? The only thing he's been charged with is 922G. There's no discussion on that call about a murder.
You probably wouldn't say no evidence about that one, though.
But that's the point, is they have to put knowledge in Ms. Jennings' head that she knows that he has committed a murder. She has no knowledge of that. The last report she looked at made March 2nd, made no reference to McFadder. She does not look at any report after March 2nd in anywhere in proximity. It's months, literally months between March 2nd, when she looks at the report about the March 1st incident, and May 31st, when that call happens. There's nothing to connect that conversation to the murder. He's not even imprisoned on the murder at that point. The police don't even know he committed the murder at that point. So there's nothing to say she knew that that he was a murderer. And the second problem is, okay, so let's imagine she knows that and she says to him, there's no evidence. That's not a crime because it's not assisting him. Defense lawyers tell defendants every day, I've looked at the evidence, there's no evidence against you. And you can say, well, that's not her role. It's not assisting him in any way. He's incarcerated. And so he can't escape. She's not helping him break out of jail. There's no discussion on there about silencing witnesses. There's no discussion on there about falsifying evidence. There's nothing that this court has recognized as accessoryship during that call. So even if you believe—
That again is if you're focusing on the murder, right? There are some when he is not in jail, where some of those considerations might be at issue, right?
Well, you mean there's some calls when he's not in jail?
Yeah.
Okay, so backing up to that, McFadder is shot on March 5th. There's calls on the first and second. As a matter of law under Hawkins, those don't count. This court has said that you cannot be an accessory based on actions taken prior to the victim dying. And McFadder doesn't die till the 5th. And Ms. Jennings does not go back into any database. She talks with Turner on the 6th. No database searches of any sort in connection with that. She talks with him on the 8th. That's in an incident where Turner is shot at. And what she says in her interrogation, assuming that's can be used, and setting aside the Garrity issue for a second, what she says at the interrogation is he called and said, they took my car into custody, who would I go see? And she told him the phone number or the contact person that you go see about your car being taken into custody. There's no evidence that she knew anything, that conversation was any way tied to the murder or to the February 17th AWICS.
Okay, we've kept you up here a long time, but do you want to say something about your interrogation
Yes.
claims?
Yes, thank you,
Just
Your
real
Honor.
quickly, so then we will, Ms. Joseph, give you time as well.
And I appreciate the court's indulgence on the time. So with regard to Garrity, more than 60 years ago, the law has been, for more than 60 years, the law has been perfectly clear that an interrogation of a police department employee who knows she can be fired for failure to cooperate with the interrogation is coerced for Fifth Amendment purposes. The uncontested record here at the suppression hearing, testified to by Detective Fultz, who conducted the interrogation and who directed the officers, other detectives.
Stop. Sorry, I got to stop you there. Your theory is that if the public employee simply knows that they could be fired if they don't agree to the interrogation, that satisfies the Garrity standard, that would mean that virtually no public employee could ever be interrogated in connection with a crime, right?
Well, so I think I'm not saying, I don't think I'm saying what the court said. What the case law says is that there's two different ways you can satisfy the Garrity standard. One is if there's an overt threat during the interrogation itself. That's one test. The other test requires a showing that's subjective and objective. The defendant would have to put in evidence that she subjectively believed that she would be fired, and that belief was objectively reasonable.
Right.
And that evidence was satisfied here. The detective himself who conducted the interrogation testified without objection from the government that Ms. Jennings knew, the quote was, she works for the police department. She knows that if she does not cooperate, she's fired, she's gone.
Right. So you're saying that detective can speak to what was going on in Ms. Jennings' mind? Seems like you would not want to establish that, have that established as.
The evidence came in without objection. So that is the record. And the government, an opposing party, can be held to admissions by their—
It's an admission that has that we cannot credit in any way, shape, or form. How could the detective possibly know what was going on in Ms. Jennings' mind?
Because he had 4 hours of interaction with her during the interrogation, including coming into the room. So he had interaction with her, and he testified after interacting with her, directing her to be picked up, bringing her to the room, interacting with her, where he had all the discussions about you're part of the family and this could have employment consequences. There's over and over discussion. He then testified that she knew as a member of the police department that she could be fired, that she would be fired. She'd be gone. So I think there's absolutely a basis based on his interactions with her for hours, including interactions before he gets in the room. There was no objection to that testimony by the government. The government, it was introduced by trial counsel. The government did not object, did not move to strike, and in fact, addressed it on their own cross-examination.
I mean, I see Garrity as a prophylactic case, right? Government employers cannot threaten, perhaps implicitly, but certainly explicitly, their employees or require them to participate in interrogation at the threat of losing their job. That's a narrow exception to sort of standard interrogation procedures and in standard Fifth Amendment law. How did that happen here? There's no indication that there was any policy. There was, and part of this is that there was no ability for the trial court to dig into this because this claim simply wasn't raised in the trial court, but we put that aside for a moment. There's no exploration of what type of policy was in place at MPD, what Ms. Jennings knew about any such policy. There was no evidence that anyone told her that she had to participate in the interrogation on the threat of losing her job. So the fact that she might have believed this somewhere in the back of her head, I don't think is what Garrity is all about.
So respectfully, Your Honor, the cases that the government cites actually explain that that is only one of the two ways that one can establish a Garrity violation. The government cites the case, for example, in Dorado, and the other cases they cite Wells, in which the court holds, those courts hold that there's two ways, two tests. One is the overt threat test, the prophylactic example that you're talking about where the government overtly threatens it in the interrogation. But the case law is, again, crystal clear, and including beginning with the DC Circuit's decision in United States versus Frederick.
All right, we don't have a case in this court saying anything about implicit Garrity.
Correct. The case law that government cites, including the Dorado case, including the DC Circuit case Frederick. I'm not aware of any court that has disavowed the alternative test.
Are you saying that there was no overt threat here? Are you conceding that? Or are you just saying that even if there was no overt threat, the second test was met?
So we are arguing that all the talk about your fate, you're making decisions with regard to your job, you're part of the family, this could have employment consequences to you. We are saying that's an overt threat. But even in the absence of the overt threat, there's a second way that the case law, beginning with Frederick in the DC Circuit and continuing through the Ninth Circuit and the other case at 11th Circuit, those courts have held there's an alternative test. It's not just the prophylactic, you can't threaten people. It's if the defendant introduces evidence about their subjective belief and its objective reasonableness, you can satisfy the test.
And
here,
am I correct in thinking that Garrity does not require, for its rule to apply, does not require that the employee have invoked her Fifth Amendment rights or have testified that she would have, but she didn't because of the threat? Or...
Correct. What the case law says is you have to establish subjective belief and objective reasonableness. And here, in a context in which it's a suppression hearing, so you're not strictly bound by the rules of evidence, there was evidence introduced from someone who had interacted with her, who had made the comments about you're part of the family, about how this could have employment consequences, who himself knew the policies, who testified he didn't care what in internal affairs was going to do because internal affairs is more concerned about protecting Garrity. He said at the end of the day, after interacting with her, he went into the grand jury and said that she was a police department employee and she knew she would be fired. The government did not object to that testimony, did not move to strike. The rules of evidence do not strictly apply in suppression hearings. And so the uncontested record is that she did know. The government hasn't argued on appeal that evidence wasn't inadmissible. They haven't argued it can't be credited. They haven't argued that he was wrong. They haven't argued that Detective Foltz was wrong about the policy.
Can you point me to where in the trial court Ms. Jennings raised a Garrity claim?
So that is a question about how specific she has to be to raise the Garrity claim. She filed a written motion that specifically raised a Fifth Amendment coercion argument. At the hearing on that motion, she elicited this testimony. And I don't think that this court's case law requires that she go so far as to say the word Garrity. She said coercion, and Garrity is a coercion.
But
case.
she did not talk about coercion with respect to losing her job, right? At no point in the trial court.
She introduced that evidence during the suppression hearing. She elicited that testimony during the suppression hearing. So when her lawyer was putting on the case, it's a Fifth Amendment coercion argument that he made, and he elicited during the hearing testimony about this. At a minimum, so I think that that's sufficient to just to address the straight up Garrity argument. He also made a totality of the circumstances argument, and one of the circumstances that he offered in the hearing was this circumstance.
And
So-
let's assume for the moment you're stuck with plain error analysis on there,
Mhm.
on this, despite what you've just said. Has she shown that anything she said during that interview, that interrogation affected her substantial rights?
Absolutely. Your
Because she denied involvement, of course. She denied culpability. How did it affect her substantial?
So to start with, they introduced the interrogation video into evidence at trial. They spent 8 pages of closing argument arguing about the interrogation video. And in particular, they argued in the closing, the only event they argued in closing really with regard to AAF was March 8th, the call, the day that Turner was shot outside the CSOSA office. So she talks to him for 24 minutes that day. Their entire argument, to the extent it exists around AAF, is around that March 8th event. And they argue extensively what she said in the interrogation with regard to the March 8th incident as supporting AAF. So that's argued extensively over 8 pages of the closing. It's used to obtain the search warrant for her cell phone. And there wasn't a Castigar hearing to look at other potential uses, such as, for example, whether informed strategy in any way. But at a minimum, it's introduced into evidence, it's argued for 8 pages in closing, and it's used to obtain the search warrant.
On your Castigar point, I'm a little confused by that. There was never a grant of immunity, right, to Ms. Jennings?
Correct. Other than the department's grant, but I don't think that Castigar, I think the law is clear that Castigar is not limited to instances in which there's a formal grant of immunity. The government's own cases that they cite, the 11th Circuit case, one of the 11th Circuit case, I think it's Wells, applies Castigar to a Garrity violation. The DC Circuit's decision in Slough, SLOUGH, applies Castigar to a Garrity violation. So the typical instance in which you have a Castigar hearing is in an instance which there's been a formal grant of statutory immunity or otherwise. But when there's a violation of Fifth Amendment rights, Castigar holds that there has to be a hearing to determine how the government, if at all, has used that. And there's no distinguishing among the type of Fifth Amendment violations. There's a coercion, and as a result, there had to be a Castigar hearing.
Mr. Martins, we've given you lots of time, so we will give you a few minutes on rebuttal as well, but we'll hear from your co-counsel.
Thank you, Your Honor.
Good morning. I'm Madeline Joseph from Sidley, Austin, and I'm here on behalf of Derek Turner. Multiple errors infected Mr. Turner's trial, and his convictions should be reversed. First, the government agrees that Mr. Turner's obstruction-related convictions must be vacated. The over 100 months to which Mr. Turner was sentenced for obstruction and related charges should be erased from his sentence. Turning to the other convictions, several independent errors require reversal. But I'll start with the warrantless seizure of Mr. Turner's car, because that seizure set off a chain reaction that led to Mr. Turner's arrest, the charges in this case, and his convictions. Specifically, the seizure of the car led to the recovery of a 10mm gun from the locked glove box in his car. That firearm was later linked to the crimes at issue here.
So under the automobile exception, how was there not probable cause to believe that the car would contain evidence of a crime?
We think that there likely was probable cause to believe that the car would contain evidence of the shooting that had happened at Mr. Turner, right? So ballistics evidence. But the car was shot on the driver's side door. That was it. There were no bullet holes anywhere else in the car. So that doesn't mean that there would be probable cause to search the rest of the car.
Well, they got a warrant to search the rest of the car, right? So for the automobile exception purposes, we're talking about the seizure of the car and taking it to the impoundment lot, right?
We are talking about everything that happened after the seizure of the car. Our argument is that the firearm and everything else seized from the car are fruit of the poisonous tree from the unlawful seizure.
No, but right. But what I'm saying is, at the moment they took the car to the impoundment lot, they needed to satisfy the automobile exception, right? And that's satisfied by finding probable cause to believe that evidence of a crime would be in the car. And it seems like you just conceded that there was probable cause to believe that evidence of a crime would be found within the car.
So I think two things. I don't want to concede that the seizure of the car was justified. I think that there could have been probable cause to do what they did to the other cars at the scene that were shot at, which was search the cars at the scene for ballistics evidence. That's less intrusive than what the government did here, which was just impound the victim's property. At the time, Mr. Turner wasn't a suspect in any of these crimes. So it's the equivalent of if my car gets shot at, on the street outside here, and I'm not a suspect in any crime, just impounding my car because I refuse to consent to a search of the scene.
So you've wrapped a few things into that. One is a suggestion that how the police go about assuming there's probable cause to believe that there's evidence of a crime in the vehicle, that how the police go about conducting that further investigation is a Fourth Amendment issue. Number two is that someone who is not yet established on the scene as being a suspect in the crime can't have their vehicle. They don't satisfy the notion of probable cause of evidence of a crime being in their vehicle. And I don't think any court has ever said that either, right?
The government doesn't point to the opposite either, however. The government doesn't point to a case holding that the Fourth Amendment authorizes warrantless impoundment of people's cars simply because they were victims of a crime.
But at the time police officers do these types of things, they don't know who's a victim, who's a suspect. They don't know what happened. We don't want police officers making those types of calls at the time, right?
They don't rely on the fact that all they rely on in impounding the car and in getting the warrant later, which we think does not cure the problem, is the fact that his car was shot at and that he was a victim of a drive-by shooting. So I think we do frankly want police making those sorts of determinations in deciding how intrusive they should be in terms of seizing property and in terms of searching property once they impound it. I mean, the problem here is not just that the police impounded Mr. Turner's car. It's that after they impounded Mr. Turner's car, they didn't just, take the bullets out of the driver's side door. They searched every single inch of the car, including locked and closed compartments.
They had a warrant to search the car, right? So then I guess the only question is whether that warrant extended to opening the locked glove compartment. I mean, it's not your position that once they obtained a warrant to search the car, that they had to search it sort of quickly and not intrusively, or is it other than the glove compartment?
It's our position that the warrant doesn't cure the problem. In order to cure the problem, the government argues that the warrant cures the problem because it's an independent source. That doesn't make any sense here because the police admitted that the only reason they got a warrant in this case was because they were seizing the car, impounding the car. The police in the warrant affidavits talk about the impoundment and seizure of the car. So there's nothing independent about the warrant here. The warrant can't cure the initial violation under those circumstances, under the independent source doctrine case law. So we don't think the warrant fixes the problem. We also think, frankly, that the warrants, are dubious. It's dubious that there was probable cause to search the locked glove compartment, the trunk, the seat pocket in the backseat of the car.
What is it that the warrant says? It's searching for identity of the shooters and information, I guess, ID information about the mysterious woman who came and asked to get into the car and then left. Like, what's the problem with that?
Yes. So the police had two justifications for expanding the warrant to search for everything in the car. The first was that they thought that the car might contain evidence of motive of the shooters, which I frankly don't think that that's true. I mean, I don't
seem to already see this as, a fallout from a feud, right? That's what they were thinking.
They do not say that in the warrant application. We later learned at the suppression hearing that Mr. Turner's name had come up in the investigation, but they do not rely on any of that in the warrant. They simply say, we think there's going to be evidence of the perpetrator's motive in the car, which to me, again, doesn't make any sense. Taking an example of, my car being shot at randomly on the street, I don't know that the government could come in and get a warrant to search every inch of my car to believe because they think that there would be evidence of why the perpetrator shot at me. I don't know that that really establishes probable cause to go into every part of a car. And then the mystery woman, she identified herself as Mr. Turner's girlfriend. She wanted to retrieve items from the car. That is perfectly innocent behavior. I mean, there could have been something she needed in the car. And I don't think that establishes probable cause to search the entire car either.
At what point in time did Mr. Turner withdraw his consent for a search? That's mentioned, but I don't have the timeline in mind.
Yes. So the shooting happens. Mr. Turner, immediately after the shooting, goes back into the CSOSA office. In the meantime, police arrive at the scene. They sort of secure the scene. They speak with the owners of the car. Mr. Turner initially consents after a little while. Then he leaves again and comes back and withdraws his consent. So it's all within the matter.
So it's before they impound the car.
It's prior to their impoundment of the car. And in fact, at the suppression hearing, the police explain, we impounded the car because Mr. Turner refused to consent. That apparently is a policy that they have that, in instances where people refuse to consent, they may choose to impound the vehicle and do a sort of fuller search. But the other cars, the other owners consented, the other cars were processed at the scene. The ballistics evidence was processed at the scene, and they were not searched top to bottom like Mr. Turner's car was. Yeah, so I do want to emphasize that we do really think that the warrants did not cure the problem here. That's the government's position, but the warrant, in order to cure the problem, the warrants would need to be independent, and there was nothing independent about the warrants from the seizure. And then I would like to just briefly address the second Fourth Amendment argument that we have. If you have no other questions about the car warrant at this.
Let me just make sure I understand your point. The warrants were not independent of the seizure. What do you mean by that exactly?
So the independent source doctrine requires that the warrant or other authorization be independent of the initial unlawful search or seizure. And so there are two ways that courts think about independence. One is whether or not the warrant was obtained independent of the initial.
Right. I mean, the way it usually
right?
works is, we found something when we did this first search, so now let's go get a warrant and we'll search for more. And
Right.
answer is no, 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 no. You're relying on something you shouldn't ever have found because you violated
Right.
rights. So yeah. But I'm not sure how that works here because had they found anything at the time
No, that you're.
so
correct.
how is it not independent?
That is the typical fact pattern where there's some sort of evidence found in the unlawful search and then they rely on that evidence in the warrant. That did not happen here. But I think that the independent source doctrine still extends to this sort of fact pattern because the point of, these exceptions to the fruit of the poisonous tree rule is to figure out if basically something broke the chain of causation. There was something independent and lawful that happened that just means that it doesn't matter that there was an initial violation of the person's Fourth Amendment rights. And that's not what happened here. I mean, the government admits that they would not have got that. The only reason they're getting the warrant is because they decide to seize the car. They talk about the seizure in the warrant. And we have no finding here from the trial court that the warrant was independent of the seizure.
But the warrant had to be independent of the seizure, right? There's no basis you would agree that the officers could have left the car where it was, but blocked entry to it by anybody, right? And then gone and obtained a warrant and searched it on the spot or towed it and searched it, regardless of what they had done before that.
I think we would still say that we think the warrant is overbroad, but
No, I'm
Yeah.
talking about independent source.
yeah. Right, but then they haven't, then arguably the scope of their seizure is reasonable and within the scope of the automobile exception. We do take issue with the intrusiveness of the seizure. in
I
this
know,
instance.
but my point is, what does that have to do with the obtainment of the warrant?
Because the police themselves admitted that they only got the warrant because they towed the car. They would not have gotten a warrant if they had left the car there.
But if they had wanted to search the car, they would have had to have gotten a warrant unless they used the automobile exception and probable cause, to which they didn't do. I mean, they actually took the further step and got the warrant
But they
to search the car.
got a warrant that permitted them to search much more broadly.
Okay. I
Then
mean,
this-
we're
then the
talking
search
about-
of the
we're talking
scene.
about- We're talking past each other,
Yeah.
but
I just wanted to say a word about the other Fourth Amendment violation. After the police found the firearm in Mr. Turner's car, they arrested him on firearms charges. When they arrested him, they seized 2 cell phones, and the police later got warrants that allowed them to search every record, everything for all time on those cell phones. And we argued that those warrants were overbroad under the court's decision in Burns, which forbids those sorts of sweeping, unparticularized warrants. The government has arguments that Burns is distinguishable because Mr. Turner was a suspect here and Burns wasn't. But, you know, as we argue in our briefs, the government's argument simply amounts to the idea that the police, if they have evidence someone is a suspect in a crime, can get a warrant to search absolutely everything on their phones for all time, as long as they recite that criminals tend to store evidence on their
It
phones.
seems like your bigger problem in this Burns issue is the good faith question. And I know Burns looks okay for you on that, but our subsequent case law of Abney and JFS seem to present a hurdle to you.
Yes, Abney and JFS did decline to apply Burns, did apply the good faith exception. We think that those cases are frankly different. The warrant in Abney did not actually authorize as broad of a search as the warrant here. The warrant in Abney only authorized the police to search for data and not for like all records on the phone, which here I think includes like all of the social media, all of the Google searches. So there was more encompassed in this warrant. And the other differences between here and Abney, I think are, you know, in Abney, there was a very discrete crime and it was a single robbery. This is a period, you know, they're searching for evidence related here to this year-long period, this year-long feud.
But those aren't the judgments that we're asking law enforcement officers to make when we're applying the good faith exception, right? I mean, you're asking them basically to second guess the magistrate judge's issuance of the warrant here. And the only narrow situation in which we say that that's required to preclude application of the good faith exception is in the case of bare bones warrants, right? And I don't, you've actually said the opposite here, which is that the warrant is broad and sweeping. Are you also saying it's a bare bones warrant that the officers could not have reasonably relied on?
I don't know that I agree with you that the good faith exception is limited to bare bones warrants. I think the problem in Burns was that the warrant was so sweeping and so resembled a general warrant that any officer who is reasonable and who is familiar with the Fourth Amendment should have known not to rely on it. And that's our argument here, that this warrant authorized just a sort of fishing expedition into Mr. Turner's phone, and that, you know, a reasonable officer should have known that those sorts of fishing expeditions were not authorized.
You refer to this warrant as authorizing a search for all time, and there is some language about before and after the time periods of the shooting. There's a reference to a shooting that began on May 10th of 2016, and then a reference to periods of time before and after the offenses. Do you think that is fairly read to mean for all time? I mean, take your point that there's no fixed limit to it, but in context, is it really fairly read to mean that?
I do think it is, and here there was an admission by the officer that the warrant contained no time limits, so that they could extract the entire contents of the phone and use everything for all time, which they did. They did in fact extract the entire contents of the phone without regard to how far in time it was from the incidents at issue here.
There was an admission at the suppression hearing, is that what
Yes,
you're
I
referring to?
could find you a citation if you would like it. The government's brief actually refers you to it, so I can find that for you on rebuttal.
Does the cells case have any application here?
The cells,
The cells case is one in which the Tenth Circuit said, well, when you look at a warrant that's overbroad, you have to ask whether or not, for the most part, the warrant was good. And
oh,
if it turns out that some parts were overbroad, then you see whether it's saved by the fact that for the most part, the warrant was good, and whether, and then you address whether the evidence that was found based on those legitimate parts was admissible, et cetera. That's cells.
right. Yeah, the government doesn't, I don't think, argue severance here, but we don't think it applies. We
This
think-
court talked about it in Burns a little bit.
Yes, exactly. We don't think it applies here. I mean, there were two narrow aspects of the warrant that maybe were supported. There was evidence that Mr. Turner's associates had posted on social media. And there was evidence that, on a Google account associated with Mr. Turner had searched for information about these shootings. Now, even assuming that those things establish probable cause to search his social media and, for all of his Google searches, those would arguably be the only parts of the warrant that would be severable, but they make up such a small part of the warrant that here, I don't think it makes sense to apply the severance doctrine and allow those pieces of the warrant to stand. You would want to just kill the whole warrant, I think. And also the government, I don't read them to be arguing severance.
If you don't have anything more to say about the Burns issue, can I ask you a question about your sufficiency claim?
Yes.
Okay, were there any, it's hard, it's a big record. Is there any eyewitness who says something like your client, Mr. Turner, I saw him, commit this shooting? I know there's the person with dreads or whatever, but anyone who identifies your client as the person who had to have been the perpetrator, or is it just the white car, the cell phone tower evidence, and the ballistics?
You're correct. It is just those things. There is no eyewitness who identifies Mr. Turner at any of the scenes.
I mean, what is the most, it's not the thing that I should ask you, but the most damning piece of evidence that is, tied to your client?
The thing that's closest to an identification is arguably, a person with a distinctive hairstyle and a certain outfit, perhaps who was like a dark jacket, who was seen at the scene, but there is nothing more than that in terms of identification evidence.
There's the ballistics, which are used a lot, and one thing I wondered about that is whether there was an objection to the expert's testimony, but we have case law saying that it's plain error for an expert to say this shell casing or whatever came from this particular gun. There's a case called Jeter that wasn't raised in the case, and that the government, that seemed to be a piece of evidence that the government used to say, well, seems like the same person committed all of these shootings.
They did use ballistics evidence. They used the sightings of the car. I mean, but we do believe that putting it all together, it's all, exceptionally circumstantial and was not sufficient evidence to convict him of these.
Okay. Thank you.
Thank you.
We will give you some time on rebuttal. Hear from the government.
Good morning. May it please the court. Elizabeth Gabriel on behalf of the United States. I'll address Ms. Jennings' claims first and then turn to Mr. Turner's claims. Beginning with the sufficiency of the evidence for the accessory convictions, there was ample evidence in the record here to show that Ms. Jennings had knowledge that Mr. Turner had committed the McFadder murder, and I'll focus on that since they focused on that, and that she acted personally to assist him in avoiding detection, apprehension, trial, and punishment. I'll talk first about the knowledge evidence, and then I'll turn to the acts of assistance. We know based on the entire record here that Ms. Jennings and Mr. Turner had extensive communications that spanned a period of 6+ months, nearly 8 months, starting in November of 2016 after the Wheeler Market shooting. In January, following the shooting of Devin Hall, she has repeatedly searched for warrants in his name. In February, in the lead up to the March 1st murder, she has, within a 2-week period, looked at police reports of 3 different murders, all after speaking with Mr. Turner, and then calls him back. She knows, based on the February 17th police report, that's the shooting of McFadder in which he was not injured. She knows from that report that Mr. McFadder was the victim and that the suspect emerged from a white car. And we know that she knows that Mr. Turner drove a white car because she had searched for and assisted him with a parking ticket earlier that month. So leading up to the March 1st shooting, she has all of this background knowledge. She knows he's concerned about law enforcement. She knows that he's asking about shootings, which she has no business looking at the police reports of, because she's merely a customer service representative. And there's a flurry of communication and phone calls around these events in a very short period of time, 2 weeks before the McFadder murder. That's all leading up to it. Then on March 1st, within less than 10 minutes after the shooting of McFadder, which proved fatal, Mr. Turner calls Ms. Jennings. The next day, very first thing in the morning when her shift begins, she looks at the police report for that shooting, and she looks at it twice, and she calls him back. After March 2nd, she calls him on March 6th, and this is now after Mr. McFadder has died. He calls her on March 8th when his car is seized, and they speak for a lengthy period of time.
So, Ms. Gabriel, I guess all of this goes to, touches on Judge Thompson's question earlier in a way, but what you're pointing out, I think, shows something that I don't think anyone disputes here, which is that a lot of bad stuff happened. There were a lot of communications between Ms. Jennings and Mr. Turner, and Mr. Turner was clearly very interested in what was going on with law enforcement about all these bad things that happened. I also think everyone can agree that the jury can draw reasonable inferences about the evidence as to knowledge to some extent, but we still don't have any indication. So I guess the question is, at what level did Ms. Jennings have to know that Mr. Turner actually committed an offense? And what is the actual evidence that she actually knew that? And if you could just tick off 2 or 3, 4, whatever pieces of evidence that show those 2 things, I would appreciate that.
Sure. We do have to show that she actually knew, that she had actual knowledge that he committed these offenses. And here's the evidence. If there's any question about what might have been said in these phone calls, because we don't know the content, we need look no further than her statements before and after his arrest. So we know that in January, she's looking up warrants at his request. Within a 2-week period, she searches at least 4 times for warrants in his name, and she reports back, "You're still good." Then we know that after Mr. Turner's arrest, she is reporting to Marche Hazelwood in a March 31st call that the police are not fishing, that there's no evidence, and Ms. Hazelwood then tells Mr. Turner, based on that Ms. Jennings has saved the case.
Right, but isn't it possible that, and I get the tension here is that the government didn't have to disprove innocent explanations, but isn't it possible that Mr. Turner could be saying, or Ms. Jennings could think that Mr. Turner was saying, "I didn't do this, and I need to know whether anyone thinks that I did this," right? I mean, that's a perfectly reasonable explanation. I'm not saying a jury had to draw that inference, but.
Is it possible? Certainly. Are there other possible inferences? Yes. But the jury wasn't required to ignore the very extensive evidence of their, lengthy history of communications, her knowledge that he was concerned about law enforcement, her knowledge that he was calling her right after his commission of these crimes. She looks at the reports, she reports back to him. The jury was, permitted, they didn't have to leave their common sense at the door. They could put two and two together and draw the conclusion that in fact she did know. And the question on sufficiency review, of course, looking at the evidence in the light most favorable to the government, is whether there is any rational juror who could draw that inference. We think that based on the evidence here, the pattern of conduct, Miss Jennings' unique position to be able to share information, and her willingness expressed in these text messages to provide that assistance is substantial evidence of her knowledge.
I take it from your responses that you agree with Mr. Martin's point in response to my earlier question that it was not enough that she might have known about his involvement in a conspiracy to commit acts against a rival gang. She had to know about his involvement in individual incidents. Do you agree with that?
Well, I agree that that's how this case was charged. That's how the case was charged. That's how it was argued to the jury and how the jury was instructed. So I think for purposes of this appeal, we do need to focus on her actual knowledge of his commission of the crimes.
You're not conceding that more generally. It's the way it
No, I
was
don't
charged.
concede that more
Fair.
generally.
And I know you're focusing on knowledge now and not assistance, but given that you referred to this statement, you're still good. I'd like to hear you address Mr. Martin's point about how a statement like that doesn't help him flee. A statement like that tells him you don't need to flee, you're good.
Sure.
So if you want to answer
Yeah.
that later and keep going on your other points, that's fine, but let's put a pin in it and maybe you could.
No, I'll address that now. I think Ms. Jennings' view of the assistance that satisfies accessory after the fact is much narrower than this court's case law recognizes. In Outlaw, this court explicitly stated that the examples provided were not an exhaustive list. And that in fact, and this is from Outlaw, any assistance, whatever, given to a felon to hinder his being apprehended, tried, or suffering punishment is sufficient. Now, if we, when we look at what she did after the McFadder murder, we know that she's reporting to him that she knows the status of the police investigation. She's looking at the Cobalt reports. And in the summertime, in May, in July, she affirms again that there is no information. She has double checked. And Miss Hazelwood says this to Mr. Turner in the jail call, that Miss Jennings is double checked and that they're not fishing, that there's no evidence.
How does that help him avoid capture or whatever?
Well, it allows him to move forward with his scheme to obstruct justice by having Miss Hazelwood take responsibility for the gun and therefore allow him to evade punishment for the commission of the violent crimes. So that's how we think, following his arrest, that's how this assisted him. Knowing that the police weren't fishing, that they had no evidence, he could present that defense. He could get Miss Hazelwood to take responsibility. And that would allow him to avoid trial and punishment for the violent crimes. I do want to note that that Miss Jennings, didn't in her opening brief raise this argument that we could only look at the evidence following the death of Mr. McFadder. But I think, as I've tried to address here in oral argument, there was sufficient evidence of that. If the court disagrees and finds that there wasn't sufficient evidence of her assistance following McFadder's death on March 5th, we would ask the court to remand for entry of judgment on the lesser included offense of accessory after the fact to assault with intent to kill while armed, because we think that even her assistance between the shooting on March 1st and Mr. McFadder's death on March 5th was sufficient to support that conviction. But again, we think that she is still providing assistance in the summertime. She is still sharing information.
And what is the evidence of that, assuming they're right about the death issue?
Right. They take issue with the fact that she hasn't looked at Cobalt reports after March 2nd. Now, she does view the Cobalt report for the March 1st murder in September when Mr. Turner is arrested. But, if we're only looking at, whether there's not evidence that she shared that information, or at least there's not communication showing that she shared information about that September viewing with Mr. Turner. But we do know that she looks at the Cobalt report on March 2nd, and there's a series of calls after that with Mr. Turner. So the jury could reasonably infer that she was sharing information about what she viewed in that report with Mr. Turner during that time.
After the death, and so.
I'm sorry, I'm talking about before the death.
Oh, okay.
Right, so her actions between March 2nd, essentially March 1st, and March 5th.
Uh-huh.
So even during that time period, she has acted as an accessory, viewing the reports, sharing in the information. It would be an accessory to the assault with intent to kill at that point because Mr. McBatter had not died. But again, we think that, based on the pattern of conduct here, the relationship among the parties, and Ms. Jennings' false denials in her interview, that the jury could draw the reasonable inference that she both knew of Mr. Turner's commission of these crimes and that she acted to assist him.
Isn't there some point in your brief where you're talking about the false denials not being that big a deal when you're arguing a harmlessness issue?
We argue that in our harmlessness section, but even if that, in viewing sufficiency of the evidence, the court looks at all of the evidence that was admitted at trial. And we do think that her false denials had probative value. And they supported the evidence showing that she knew, and they supported the inference that she knew what was going on and that she acted to assist him. And I do just want to point out, Mr. Martins made the point that that knowledge had to be shown by direct proof, and I don't think that's correct. Under Clark, this court made clear that evidence of knowledge and intent, and I just think as a general matter, the court has consistently recognized that evidence of knowledge and intent is often not found in direct proof. There's often not direct proof of that. And so we look to circumstantial evidence, and that evidence is given equal weight to direct proof. So here, again, we've shown substantial circumstantial evidence of her knowledge and intent. I can turn to the Garrity claim if the court doesn't have any other questions on the AAF convictions. First, I do want to note that our position is that this claim is not properly before the court. It was waived because it wasn't raised in Ms. Jennings' pretrial motion. She did not alert the court that it would need to apply the Garrity framework, that it would need to make the requisite findings of a subjective belief that's objectively reasonable or an overt threat. And therefore, the court should not consider the claim.
So you're saying waived as opposed to forfeited? And
Yes.
not considered?
Yes. If the court chooses to consider the claim, we think the plain error standard applies. But regardless of what standard is applied, Ms. Jennings has not shown a Garrity violation here. She hasn't shown that there was an overt threat. She hasn't shown that she subjectively believed that there was a threat of termination and that belief was objectively reasonable. In fact, the evidence was to the contrary. She was repeatedly told that she was under no obligation to speak with the police. And she acknowledged and affirmed that she was there not because she felt obligated, but because she chose to be there. She affirmed that she understood that she could terminate questioning at any time. She affirmed that she felt under no pressure to answer their questions. And just viewing the circumstances and viewing the video itself, it is quite evident that she feels relaxed and doesn't feel coerced in any way.
What about the officer's testimony about her subjective view? Do you think that's valid evidence to consider on this point?
No, we think it's irrelevant. I mean, his testimony in the grand jury doesn't answer the question of what she actually knew. To prove a Garrity violation, in the absence of an overt threat of termination, Ms. Jennings would have to show that she actually believed that she was under threat of termination. So just whatever Detective Foltz may have believed is neither here nor there.
If she told him that, would he be able to, would it be valid? I mean, I suppose you'd have it.
I mean, if she told him that, then certainly I think there would be some evidence then that she subjectively believed. But then the question would be, was that objectively reasonable? And in looking at objective reasonableness, I think we need to look at what was communicated to her, and whether there was, some policy or regulation that was expressed to her, or a threat that she would lose her job if she didn't cooperate and speak with them.
In what way did some of his statements to her fall short of being an overt threat? He said some things that sounded like, if you don't cooperate, you won't have a job.
Well, he does say, you're making bad choices. He says, you could be fired for this. But that comes in the context of a conversation about what she had done, her misuse of police resources, her misuse of the databases. So he goes through the evidence and says, you've been looking at Cobalt, you've been running whale searches, you could be fired for this. Speaking about her conduct, not about whether she decided to speak. And that's a completely different issue. Again, based on her responses, it is very clear that she felt under no obligation to be there. And she explicitly said that she was there because she chose to be there. So there's just no evidence in the record here of a Garrity violation. I can talk about I'll turn to Mr. Turner's claims unless the court has further questions about Ms. Jennings' claims. Looking first at the seizure of the car, Mr. Turner concedes that there was probable cause to believe that his car contained evidence of a crime. Under the Fourth Amendment, that was all that was required. Under the automobile exception to the Fourth Amendment, that was all that was required in this case for the court to seize his car. They could have searched it on the scene if they had wanted to. Instead, they took a different course of action approved by the Supreme Court, which is to seize the car and then seek a warrant.
Could they have searched the glove box on the scene?
They could search any part of the car that they reasonably believed could contain evidence of the shooting. And I think it would be reasonable for them to search the glove box in those circumstances. But again, they didn't. They seized the car, then they sought and obtained a warrant on probable cause.
And why would they have reasonably thought that the glove box could contain evidence of a crime? Your opponent says the shooting happened on the driver's side of the car, far away from the glove box.
Well, we don't know the trajectory of the bullets. That's not in the record. But we do know that it was shot up, that there were a number of bullet strikes to the car. And I think, probable cause is not a super high standard, right? So given that standard, I think that there would be evidence to show that they could reasonably conclude that there might be evidence of the ballistics evidence could have traveled through the car. But we're not talking about that here. What they seized the car as they were entitled to do. The only dispute that Mr. Turner seems to have is that, or at least in his briefing, I'll note that he never did challenge the warrant in his briefing, and so that's not been addressed. He raises that here for the first time on appeal. But the only challenge and the only dispute to the seizure of the car seems to be Mr. Turner's contention that there was not probable cause because he was a victim rather than a suspect. He cites no authority for that proposition. And in fact, there is clear authority from the Supreme Court and from this court to the contrary. And these cases weren't cited in our brief, but I'll just point the court to Zurcher versus Stanford Daily. That's from the Supreme Court in 1978. and in Ray GB from this court. Both of those cases held that probable cause to search does not depend on the status of the owner or possessor of the thing to be searched. The only question is whether there is probable cause to believe that there is evidence of a crime in the thing to be searched. We think his claim that, his status as a victim undermines probable cause is simply not supported. In any event, even if there were not probable cause, even if the seizure was invalid, the independent source doctrine establishes that this was a valid search of the car. So assuming there was some illegality in the seizure, under the circumstances of this case, the warrant was obtained wholly independently of any invalidity of that seizure. The police did not rely on any information they obtained from the seizure in seeking the warrant. None of that information, I don't think there was actually any information that they had gained from the seizure, but nothing of that sort was presented in the warrant. And so we believe that this would have been, the search itself was, and the seizure of the evidence, which is what he sought to suppress, was valid under the independent source doctrine. Again, I haven't discussed Mr. Turner challenges the manner of the search and the scope of the search and challenges the warrant, but those claims were not raised in his briefing, and so we have not briefed that issue. I can turn to the cell phone warrant issue if you'd like. This case is distinguishable from Burns, as we've argued. The 16-page affidavit in this case provided detailed explanation of Mr. Turner's involvement in the violent feud between the two gangs, the evidence establishing his involvement in the violent crimes committed.
But they're long affidavits and they do those things, but what do they do with respect to a nexus between those crimes and the phones?
Well, they do. The detective pointed to the posting of the Instagram posts from the shooting range where Mr. Turner visited. Also pointed to Mr. Turner's Google searches of shootings that had occurred in the area, and pointed out the fact that several of these crimes were committed by multiple assailants. And so we know, and Detective Weber attested to the fact that he knows, based on his training and experience, that where you have multiple assailants, often you will find communication among them in the phones. He went into detail about how he knows, based on his training and experience, how phones are used in these kinds of cases where you have a conspiracy to commit crime, essentially, and a series of violent crimes that spans such a long period of time. I think there was certainly probable cause to show that there was evidence of those crimes in Mr. Turner's phone.
I mean, maybe this is an issue courts around the country are grappling with right now, and maybe you don't have a great answer for this, but I mean, in this day and age, it seems like this could be said about virtually any crime. And I guess it is true that people use their cell phones for virtually everything these days. So at what point do you draw the line between a nexus between crimes and phones versus saying that you can pretty much search a phone for almost any crime these days? And I mean, I know this is a policy question that your office has to think about, and maybe you're not in a position to answer it right now, but
I mean, certainly it's a complicated question. And I think that, Riley recognizes that cell phones contain, a wide swath of information. But I'll just looking at Burns, for example, the Burns court found that, there was insufficient probable cause because there was really very little evidence. In fact, there was no evidence that Burns himself was involved in the crimes. And so the only real, probable cause showing was for the text messages he had exchanged with the victim and his location data. And here, in contrast, we have extensive evidence that Mr. Turner was involved in these crimes, that he had coordinated with people in committing these crimes, and that he had used technology, he had used internet searches to search for information related to these crimes. I take your Honor's point, but I think that what's required is a showing of, as you said, a nexus between the crimes and the evidence and the phone. And I think that showing was made here. But
Ms. Joseph emphasizes that this warrant allowed a search for all time, because it, as I was noting in an earlier question, it refers to the date when some shootings began, and then it makes a reference to before and after the periods of the shootings without any limitation on how far back. So what do you say about that? I mean, was it not overbroad in that respect?
Well, I think there was a temporal limit here. It was bounded by the beginning of the feud in March 2016, and included the series of violent events that had occurred in the wake of that. So it didn't permit an unbounded search for anything possibly on the phone that could show involvement in violent activities. It had to be specifically related to this feud.
What about the suppression hearing testimony that Ms. Joseph refers to? She said someone testified at the suppression hearing that the officer thought it covered all time, essentially.
Well, yes, Detective Weber did testify that that it was. I think he was asked whether there was any limit as to date and time, and he said no without explanation. But I think on the face of the warrant itself, which is what we're looking at in a Burns analysis, on the face of the warrant itself, there is a temporal limit. And it starts with the May 2016 shootings, and it goes through the period of time described in the warrant, which covers the violent crimes committed between these two gangs.
Yeah, the reference in the warrant, attachment B, is during the periods of time before and after the offenses. So how would that have told someone how far back you could go?
Well, they're explicitly tied to those offenses. So I think, you know, that is the limit that's imposed. And you know, even if you know, the court has made clear that at least, you know, even if there wasn't, even if it wasn't sufficiently particular in terms of timing, that warrants issued at that time that were limited to evidence related to particular crimes could be relied upon by law enforcement. And so we do think that the good faith exception would apply here. So under Abney and in Ray JFS, this court found that where officers had relied on warrants that limited the seizure to evidence of the crimes set forth in the warrant, to those specific crimes, that they could rely in good faith on those warrants. As the trial court here noted, warrants of this type were routinely relied upon pre-Burns, and at the time that the warrants in this case were issued. So even if there's some concern about probable cause and particularity in this case, we think that this case is on all fours with Abney and in Ray JFS, and Mr. Turner has not offered any reason why the court shouldn't decide this case consistently with those cases.
I think you also argue that anyway, it's harmless, the cell phone thing. I have a question. Is the cell tower evidence, you know, that sort of places Mr. Turner in certain locations, is that a fruit of the cell phone seizure?
No, the cell phone evidence, the cell site evidence was obtained separately from the contents of the phone. So the evidence that the police extracted from the phone that was relied upon at trial was evidence of motive. It was the photos of Mr. Turner's victims. It was the evidence of the feud between the two gangs, the video, the response to the rap video. That was all motive evidence. But And I can segue into the sufficiency part here. There was very strong evidence of Mr. Turner's commission of these offenses, of the violent offenses, apart from the motive evidence. Your Honor had asked about the identification evidence, and I do want to address that. I think that there was strong evidence of identification at each of the 3 crime scenes of the crimes of which Mr. Turner was convicted. His car was there, his gun was there, and his cell phone was either there or near there. I think that is very strong evidence that he was himself there.
Well, in many of your arguments here, like the harmlessness about the cell phone issue, the Burns issue, you say the cell phone evidence was of minimal value given. Number 1, the ballistics evidence tying Turner's gun to the shootings. And I understand this wasn't raised, I don't know whether they're pursuing an ineffectiveness claim on that or what, but is it fair to say his gun was there when we have case law saying the science just isn't there to be able to connect a gun to a shell casing?
It wasn't raised. It wasn't objected to. Hasn't been briefed on appeal. So I don't really have a response to that. I haven't really considered that issue.
I mean, it's definitely the case that when we're considering the sufficiency, we consider everything that was admitted, even impermissibly.
Absolutely.
So no question, but it's a little odd to say his gun was there when the government report on this kind of forensic analysis says that science isn't there.
I mean, what is it, is your argument, and was the testimony that there's a high likelihood that his gun was there?
Yes.
Or was the testimony that his gun was there?
Well, the testimony was that his gun had shot, the bullets that resulted in the death of his victims, or the assault with intent to kill.
So, I mean, I get, and we don't have to belabor the point that it's not been raised, but I don't think that testimony can be properly provided, but
again, on sufficiency review, we don't look under that. We take the evidence as admitted, whether improperly or not. And so this jury was told that this gun ejected these cartridges, and then could reasonably conclude that the gun was the murder weapon or the assault weapon.
Can I ask you about the cell tower, the cell site evidence? Was there testimony, I guess just how probative is that? Was there testimony, or is there any evidence in the record about Mr. Turner living in that area or working in that area, or is it like, oh, if the cell site data shows him being within 0.2 of a mile or whatever, that's significant because he wouldn't otherwise be there. Is that his neighborhood?
That wasn't his neighborhood. So he committed each of these shootings in the Trenton Park neighborhood. He lived in Waller Place, a different neighborhood.
How far away is that?
I don't know.
Because did the expert say this, you can pinpoint where he was exactly?
No. He said he was in the vicinity of, his phone used these cell towers. This is the projected range of the cell towers.
And they're like, if
can't
there's
say
a
exactly where he was.
a big building or a big landmark or something, it might flip to a different cell tower, that kind of thing. I've seen that testimony in many cases. Yeah.
Okay. But the jury was made aware of all that, and they in fact had the expert, the defense expert, who testified about the cell site evidence. So they were aware of all that, and they resolved any concerns in the government's favor. I do want to also just highlight that the sufficiency of the evidence for Mr. Turner's convictions is strongly supported by his efforts to obstruct justice and to evade apprehension. He 2 days after his arrest is speaking with his girlfriend, asking whether she has changed or erased his phones. He then, of course, as we've discussed, engaged in lengthy communications with Ms. Jennings to find out information about the police investigations to avoid apprehension for his crimes. So all of that, we think strongly supports his guilt of these convictions. There are no further questions. We would ask the court to affirm with the exception of the obstruction counts.
Thank you
Thank
very
you.
much. Okay. Mr. Martins, we'll give you 3 minutes on rebuttal.
Thank you, Your Honor. I want to go back to the question that Judge Shanker asked, where you asked the government to tick off the evidence that Ms. Jennings knew. They gave you 2 things: that she looked up warrants regarding his arrest in January. That cannot establish knowledge of a murder in March, and particularly when there is no warrant search, either as to the February 17th event or as to the March 1st event. The second thing the government said was the May 31st call where Marche Hazelwood reported back that the police, quote, were not fishing, no evidence. The government's position is that the fact that the police are not looking at Turner and that there is no evidence against Turner is evidence that Ms. Jennings knew, contrary to the evidence and contrary to the police investigation, that Turner did it. That is exactly the opposite. If Ms. Jennings actually learned that the police weren't looking at Turner and didn't have evidence, that wouldn't create knowledge that he had committed the crime. It would create the exact opposite. So the only 2 things the government cites to you for knowledge do not establish knowledge. Secondly, in terms of what inferences could reasonably be drawn by the activity, on October 4th, 2022, in trial, Detective Foltz, who conducted the interrogation, was asked. He was asked about the events on February 16th, on February 17th, on February 22nd, and on March 1st. And this is on pages 134 to 136. The last question, the last one, March 1st, 2017, Andrew McFadder. He's then asked, "You don't know why she accessed that information either, do you?" Answer, no. Question, "You have no idea what she did with that information, do you?" No. Question, "You don't know, based on these incidents, based on your investigation, whether she shared that information, any of that information with anyone, do you?" No. The officer, knowing the investigative record, said he did not know, and this jury could not know because there was no information about what was discussed. Third, this court has rejected that personal knowledge can be based on reasonable basis to believe. That was the dispute in Butler, and the dissent said reasonable basis to believe is enough to establish knowledge. The majority said it is not. Fourth, this intent to the issue about the May 31st, the question is not whether that knowing there's no evidence would have allowed Turner to do something with Marche Hazelwood. It's a specific intent crime. Ms. Jennings had to intend to assist. There's not evidence that Ms. Jennings knew anything about the plot for Ms. Hazelwood to take ownership of that gun, and specific intent is required. Fifth, if I could have just
Does the intent have to be specific to how it will help? Let's say it's shown that someone had a specific intent to help someone avoid apprehension. Do they have to, do they need to understand exactly how their information will help?
They have to do something that would specifically intend to help in one of the ways.
Right, let's say I acknowledge that I intended to help. No dispute about it.
Right.
I don't know what you were going to do with the information I gave you, by the way, but I did intend to help you. Is that enough?
You would have to intend to help with regard to the murder.
Right.
And that's the problem here, is that as of May 31st, nobody was claiming that Turner had committed the murder. As of May 31st, the only thing that Turner had been charged with was being a felon in possession when he was shot at on March 8th. Nobody had alleged publicly that Mr. Turner had engaged in a murder. So she could not have specifically intended to assist with regard to the murder. There's also a question about circumstantial evidence of knowledge. I think that there's an important distinction here, if court would give me just a minute on this. The only way you know my knowledge by direct proof is if I tell you I knew X. You circumstantially prove I knew X by showing that I was exposed to information, and the fair inference is that I knew. What the government's arguing here is for something much more. They're saying there were all these circumstances known to Ms. Jennings about Mr. Turner's interest in these events. And she should have inferred from that Mr. Turner was the perpetrator. That's not actual and personal knowledge. That's not her actual and personal knowledge. They're saying she should have suspected it. And that's exactly what Hockheimer and Lefebvre and this court's decision in Butler don't allow for, saying she should have suspected. The last point I want to make, if I can, is just on Garrity. There was some suggestion that this was not, the Detective Fultz's testimony about knowledge was not cognizable evidence. That's just not true. First of all, in a suppression hearing, the rules of evidence don't apply. But even under the rules of evidence, lay opinions are permissible if they're based on the reasonable conclusions based on personal observation. This detective interacted with Ms. Jennings outside the room and inside the room. He repeatedly said to her that she faced employment consequences, and he said that in response to her purportedly not cooperating and not admitting. He is perfectly entitled to what a reasonable interpretation of his statements were and what they would be understood to mean to the hearer. And that's exactly what he did. A foundation was laid by establishing the degree of his interaction, and a cross-examination was conducted in which he said she knew as a police department employee she would be fired.
Well, I mean, it may be admissible evidence, it may be cognizable evidence. I'm not sure what weight it has when we're talking about what someone thinks someone else knew. And this kind of ties into the sufficiency point on accessory. He was basically saying what she actually knew, and not what she could have known or should have known. But there's no way someone can say what someone else actually knew.
But see, this is where the government wants it both ways.
Well, so do you, though, right?
Well, I'll take it on sufficiency, because if it's the fact that the detective can't know by observing the circumstances of the interaction, if the answer is he can't know what she knows, then it applies the same way. What the government is saying is, well, she should have inferred from the circumstances. And the answer is, if one doesn't constitute personal knowledge, then the other doesn't constitute personal knowledge. And I have been arguing that what the government is saying is that she saw a lot of circumstances that should have made her suspicious. Hockheimer literally says suspicion doesn't count. Lefebvre, literally cited by this court, suspicion does not count. These circumstances of him calling her may have been suspicious. The question is, the particulars matter. What did he say? What did he ask?
So
And what, if anything, did he give?
I might agree with you on that, but that means I also agree with you when it comes to Detective Fultz testifying about what she actually knew about her requirement to participate in an interrogation. But
And if the court rejects me on Garrity but grants me on insufficiency, I will gladly take that. Because at the end of the day, the government, what she said is important, and what he said is important, and we just don't know. As you said, did he call up and say, I didn't commit this? Are people blaming me? What we do know is she didn't look for a warrant for him. Not on February 17th, not at any time after that. And that is a different circumstance than what happened previously. And nothing happened after the death. Just on
Ms.
that.
Gabriel says that if we agree with you on the accessory charge as to the murder, that we should direct entry of conviction on the lesser accessory to the lesser included charge of assault with intent to kill while armed. What's your response to that?
Well, I would like a chance to brief that at least. I did raise in my opening brief that you cannot be an accessory until the completion of the crime. I explicitly raised that. The government in closing argument had only argued the March 8th interaction when outside the CSOSA office as the AAF. They made a big deal about the 24 minutes and about what Ms. Jennings said in the interrogation. So they then come back and say, oh, March 1st and 2nd. In fact, they're looking back to January. And so then I cite this court's specific point in Hawkins, written by Judge Beckwith, that said, quote, a defendant cannot be convicted of accessory after the fact to murder on the basis of actions taken while the decedent is still alive, end quote, citing this court's decision in Little in 1998. It has long been the rule on that point. And so they argued in closing in a page of argument, March 8th. They now come back in their brief and say March 1st and 2nd. As a matter of law, that does not count. And that is determinative here because Jennings never, ever looked at anything with regard to the McFadder murder after March 2nd. After he was arrested and charged, she gets a call on September 6th. He's already been charged. He's already been brought to court. She looks at it. She's entitled to look at it. She's a customer service representative. She shares, there's no evidence she shared any confidential non-public information. From March 2nd to September 6th, she had no information to share. Expressions of enthusiasm or support for someone we can say is a bad thing for a police employee to do. It is not assistance rising to the level of accessory.
Take it all, that was not an answer to my lesser included question.
Well, I think it is
That
because
your
they
answer
didn't
was you
raise
wanted
it.
to brief it, right?
Well, because they didn't argue it in response. I mean, and I said in my opening brief, it has to be completed, and they didn't come back and make that argument. At least I'd want a chance to brief that because it's not a foregone conclusion as to whether or not there's a multi-part test under this court's decision as to whether or not a judge can convict based on a lesser included. So we should at least have a chance to brief that. The court's been more than indulgent with my time. Thank you so much.
Thank you very much.
We request that the conviction be reversed.
Okay, Ms. Joseph, we'll give you 3 minutes-ish as well.
Thank you. I promise to be quick. I just have three.
We've heard promises like that before.
Yeah, I'm sure. I'm sure. So first, I'd like to start with just Judge Thompson's question about the time limits of the warrant. So as the government acknowledged, Detective Weber did admit that the warrants were not time limited. The government's brief at 28 quotes that testimony, has a cite for that testimony. And the government's responsive argument is, well, the crimes provide the limitation. But, we think that under the good faith exception that wasn't enough here. First, in our reply brief at page 9, we cite a bunch of decisions from other jurisdictions holding that similar warrants that were limited to a crime but did not contain other limitations do not qualify under the good faith exception. So I would urge the court to look at those decisions. I think that this case is different from Abney and JFS in that respect. In both of those cases, there were very specific crimes, a single robbery, a single murder that the warrant was limited to. Here, we're talking not about like some crimes. We're talking about a year-long period of time in which there's all kinds of things going on. So that's not the same kind of limitation that you were facing in Abney and JFS. So we really do think that that's different. Pivoting to the car argument, I just have a couple of points. You will ask the government if it would have been reasonable for them to search the glove box at the scene. It would not have been reasonable for them to search the glove box at the scene. There was not probable cause for them to do a warrantless search of the glove box. There is evidence in the record about where the bullet holes were. The government's own warrant application says, and this is in the record, the first part of the record at page 177, that the car was shot in the driver's side door. There are photos, the trial exhibits, starting at like A13 through the next few trial exhibits that show there are photos of the car where it was shot in the driver's side door, and the only interior damage is to a speaker in the driver's side door. There was not reason to believe there was going to be ballistics evidence in the locked glove box. And it's also incorrect that this sort of argument that the search of the glove box was unreasonable and not supported by probable cause is not addressed in our briefing. We do address in our briefing the argument that the scope of the search was unreasonable. The government has maintained throughout this that they didn't actually need a warrant to do what they did. And in response, we argue, they say we had support, the support we cited in our warrant, that, there was evidence of motive in the car. There was evidence about the woman that indicated there was stuff in the car. We could have relied on that to search at the scene, and we respond to that. So it's wrong that those arguments were not addressed.
I mean, would you agree that evidence of drugs in a glove box would be relevant to an investigation of the basis for a drive-by shooting into a car?
I mean, it might be relevant, but there's no evidence that there were drugs in the glove box here.
No, but that, of course not after the fact, but at the time that officers are figuring out whether they have probable cause to, and ultimately a warrant in this case, search certain spaces that might bear on the evidence of a drive-by shooting into a car. Part of that inquiry might be, what was the reason this car was shot at? And that evidence could be in the glove box, right?
I think you need more than just speculation that the fact that a car has been hit by a bullet means that there's some evidence of contraband or some other thing in the car that caused someone to shoot at the car. There are shootings, every week in the district that cause stray bullets to hit cars or people's property. And I don't think that the Fourth Amendment authorizes the police to warrantlessly search those places for, on a fishing expedition for evidence of the shooter's motive. And that's basically what happened here. In fact, the government didn't, the government's warrants seemed to indicate that the government thought there was like some electronics or something in the car, and that's what they were fishing for. So the warrant, the first warrant authorized search for ballistics evidence and for electronics and papers. So I don't know, maybe the police thought that Mr. Turner's girlfriend was looking for a phone. They didn't think that there were drugs in the car. They didn't know what was in the car. It turned out there wasn't a phone in the car. They were wrong about that. So they were fishing. They were fishing for something.
But you would agree that Mr. Turner's girlfriend's actions immediately following the shooting could bear on the probable cause analysis as to the scope of the search, right? If she had never shown up with an eagerness to get something out of that car, and I agree with you that there may be innocent explanations for that, but it certainly is a factor that law enforcement could consider on the probable cause piece, right?
I think it's a fact with exceptionally limited probative value. She could have needed to get like any number of things with it seems far more likely that there was an innocent explanation for that than that there was some sort of nefarious explanation for that. People store things in their cars. People have car seats in their cars. People have phones in their car. People have things in their cars. It does not indicate that there's evidence of a crime in the car. She had nothing to do with it. She wasn't even at the shooting, at the time. She wasn't even on the scene at the time of the shooting. She's just coming around trying to pick something up from the car she thinks is going to be.
That's one of the bases for the automobile exception, which is that the suspect, and I know, of course, the whole premise of this is your point that Mr. Turner was not a suspect at this point, but they might have associates try to retrieve items from automobiles, even if they themselves are unable to do so. But
yeah, I think that has very limited probative value. And then my final point is just I want to return to the phone warrant and just say that the nexus here was very thin. In Abney and in JFS, there was evidence that the phones had been used in the commission of the crime. Here, there is not evidence that Mr. Turner was using his phone in the commission of these crimes. The two specific pieces of evidence about the phone in the warrant, or the two specific facts about the phone in the warrant, have to do with other people's Instagrams and these searches, which could have been completely innocent. He lived in the neighborhood. He may have been interested in all the shootings going on in his neighborhood. The basis for the nexus was the idea that he was potentially involved in these crimes and that criminals use their phones. So we think that again, those warrants were overbroad. So we would urge the court to reverse Mr. Turner's convictions.
Thank you very much. Thank you to all parties for your briefing and your arguments today. We're going to take the case under advisement, and we are adjourned.
Oh.